Good evening, everyone. Thank you so much once again for coming. We are having the sixth section of our construction law seminar series, and tonight we have Peter Burns once again kindly doing this seminar for us, and tonight he's talking about construction adjudication in the UK. Peter is an authority, especially in adjudication, with who I learned so much, and I'm happy to leave it with you. Thanks, Peter, and I hope you enjoy as we are going to.
Okay, thank you, Angelica. Today we're doing construction adjudication in the UK, and quite a few things we speak about actually has now become a bit more widespread than purely the UK, but this really concentrates purely on the UK at the moment. And I suppose really what we need to look back is to see where adjudication fits in to the dispute resolution process within the construction industry. Now, if you roll the clock back 20 years, to around about 20 years ago when the Arbitration Act 1996 came out, then there was no adjudication provisions, statutory adjudication provisions, and nearly all disputes in the construction industry were resolved at that time under arbitration, or a few in court, but more often arbitration than court. And then over a period of time, by 1998, adjudication started coming into play. And as a result of that, over the next few years, and particularly now, after all these years, adjudication is really the only means of resolving disputes in the construction industry in the UK. So what adjudication is an interim fast-track method of resolving disputes under construction contracts. So it's an interim fast track. We'll come on to those two issues in a moment. When we say interim, what we mean by that is it's binding on the parties, but you can eventually go to arbitration or court, whichever applies under the particular contract, to decide the dispute again. So it's interim, you have to comply with it at that particular time, but you can later on go to arbitration or court to not overturn it, but to decide the dispute again. And it's often been described as a pay now, argue later type of dispute resolution process. So when it first came into being, the idea was that you have a particular dispute on a particular contract, and rather than let this dispute fester on all the way through to the end, you go to an adjudicator to decide this particular dispute. And it was an interim measure, and somebody would say, oh, I think I'm owed £50,000. The adjudicator would look at it, yes, I agree, it's £50,000, and the money then passes hand from one party to the other, but knowing that eventually the whole thing could go back to arbitration or court to be decided again. So it's an interim measure, it's pay now, argue later, it's a fast track process, which we'll come on to in a moment. And because of that, often is referred to as a rough and ready process. Matthew and myself deal with it all the time, so we know that that's partially true, only partially true because obviously it's not as much information as put in court, there's not as much evidence as put into arbitration, but there's quite a bit of evidence that's put forward. The dispute is decided by somebody who's qualified, they're experienced in the construction industry, experienced in the disputes, and therefore you normally get around about the right answer from the adjudicator. And even though it's an interim measure, often people don't go on beyond that after the arbitration, after the adjudication process. They don't bother to go to court, they don't bother to go to arbitration. So although it's called rough and ready and rough justice and these types of things, in reality is not that bad, and it also does give you a very quick and relatively cheap answer for a dispute in the construction industry. And where it all came from was in a report called the Latham Report, which was formed in 1994. Sir Michael Latham was asked by the government to look into what the problems are in the construction industry. But this has been ongoing from the early 60s all the way through. Every so often another government would say, oh, can you have a look into the problems in the construction industry? And the problems always came down to payment and disputes. So always these are the two main issues. And Sir Michael Latham produced this report called Constructing the Team, and the two of the large elements that he picked up from that were the problems of payment in the construction industry and the problems of resolving disputes in the construction industry. And from that, at that time, there was already a couple of the standard forms had adjudication provisions within them, but they were purely contractual adjudication provisions, and they were rarely used in those days. But Sir Michael Latham said, well, we should have some fast-track, quick resolution method, and he recommended that there should be some sort of adjudication process. And almost as direct result of that, a couple of years later, the Housing Grants, Construction and Regeneration Act, 1996, came into force. And that act is a very long act, actually, but one part of it deals with the part that we're talking about. Part 2 of the Act is the part that deals with dispute resolution, adjudication and payment provisions. So that's where it all starts from. Now, although that's dated 1996, it didn't actually come into force until the 1st of May 1998. So it still took a while for that to work its way through. But if you look back at the Latham report, which is an interesting document to read anyway, and compare it to the Housing Grants Act, Housing Grants, Construction and Regeneration Act. We always just call it the Construction Act because it gets too much to say that all the time. Then you'll find that there's all the same types of things in the report and in the Act. And that Act, which came into force on 1st May 1998, eventually there was pressure from the construction industry to change parts of it. And therefore, as a result of this pressure, eventually, after lots of consultations with all the various sectors of the industry, a new act came out in 2009, which is called the Local Democracy, Economic Development and Construction Act. And again, only part of that act relates to construction adjudication, part 8. So the way the government works is they've got lots of things they want to cover, and they find an act to push something in, and that's where they've pushed in about adjudication and payment provisions. Well, again, that's only really an update of the old act, but there's fundamental differences as well. So if you were operating, and we have even now operating on contracts that go back prior to the second act came into force on the 1st of October 2011. So if you go on to anything that was formed before the 1st of October 2011, the old act would still apply. Anything after the 1st of October 2011 in England would be the new act. So you have to understand which act you're working on. Now, you could almost take it that always the new act would be applying. There's a little twist. If you have any work in Scotland, the new act didn't come into force until 1st November 2011 because there was a bit of issue with the government in the devolved government in Scotland just actually passing that part of the act. Now, these two acts of Parliament, what they say effectively is that any construction contract in the UK has to have a adjudication provision written into the contract. And you might think, well, if I draw up a contract and I won't bother to write anything about adjudication in there at all, then I won't have any adjudication provisions in my contract, and nobody can make me put adjudication provisions in my contract. So what the Act says, if you don't put in adjudication provisions within your contract, then this other secondary legislation, which is called the Scheme for Construction Contracts Regulations, I won't go through the whole title. This is the second scheme. The first scheme was under the old Act. This is the second scheme, but they're very, very similar to each other. And this document called the scheme, we just called it the scheme for shorthand, incorporates the provisions that are then implied into your contract. So if you didn't put any adjudication provisions into your contract, then if you just forgot to mention about adjudication altogether, if a dispute came up and it was a construction contract, then the provisions of the scheme would go into the contract as though they are written into the contract. And in terms of adjudication, if you put in terms of the contract which don't comply with the Act, so in one case you could not put anything in at all about adjudication, in which case the scheme comes in, or you could put in something into the contract which doesn't comply with the requirements of the Act, because the Act sets out stipulations of what has to be in there. In that case, those requirements in the contract are thrown out and the scheme comes into play. So it supplants what's already in the contract. So you have to make sure that if you are going to put provisions in the contract for adjudication, they do comply with the Act. So that's really what I've just said. Now, what you've got to remember also is that, I'll recap, that the Construction Act requires everything, every construction contract in the UK to have adjudication provisions. If the contract doesn't have adjudication provisions or doesn't have compliant with adjudication provisions, the scheme comes into play. So you can't escape the statutory nature of adjudication in the UK. But what you can do is you can put obviously contractual adjudication provisions in the contract that do comply with the Act. And so if they do comply with the Act, and they may enhance what the Act requires, and then in that case it becomes a contractual adjudication. If you're relying purely on the scheme, it's a statutory adjudication. It's a fine point, but later on we'll be talking about jurisdictional type issues, which is a major thing for adjudication. And one of the fundamental things is it a contractual adjudication or is it a statutory adjudication? So if it's a statutory adjudication, it relies on the scheme. If it's a contractual adjudication, it relies on something you've written into the contract that complies with the Act. Now, all of these, whether they're statutory, particularly if they're statutory adjudications, when I said that the scheme is implanted into the construction contract if there is no adjudication provisions, where we've got to start from is it has to be a construction contract. So we're not talking about anything other than construction contracts. So first of all, it has to be a contract, and secondly, it has to be it has to be a construction contract. So how you define if it's a construction contract is that in the Act it says these are construction operations, and if the contract is to do with one of these specified construction operations, then it is a construction contract. So for example, in the construction industry you might be a supplier of bricks. So you might be supplying bricks to a building site, you don't get paid, you've got a contract, you might think, I'll go to adjudication because it's the quickest, easiest way. But you look through the list in the contract, in the Act, and it will say no, supplying isn't a construction operation under the Act. If you are a subcontractor, for example, you're doing some carpentry works, then that is a construction operation because you're providing services under towards the construction operations. If you're, for example, a surveyor, then that is still a construction operation because you're providing a service again. So in one simple way is that supply contracts are not covered by the Act, but services contracts are. The other part is there's certain other fine-tuning parts, and one big fine-tuning part is a residential occupier. So if a residential occupier has a contract for construction works and there's a dispute with the contractor, then normally the residential occupier has an exemption under the Act. So it says these provisions don't apply to a residential occupier. The reason why I say normally is if the residential occupier is represented by a professional and the professional has gone through the contract and has accepted on behalf of the residential occupier the adjudication provisions, then those provisions would be accepted. Now that would be a classic situation where It wouldn't be a statutory adjudication because the scheme is not imported into the contract, but it would be a contractual adjudication because the parties between themselves have agreed these are the provisions that apply for adjudication. Another big difference between the old Construction Act and the new Construction Act is that in the past, only construction contracts in writing had the right to go to adjudication. Well, in the construction industry, obviously, often there's verbal contracts formed. I say often, quite often, or there might be verbal terms agreed or something of that nature. Now, under the old Construction Act, you had no right to go to adjudication, whether it's contractual or statutory, because if there was a verbal term, then it didn't come under the umbrella of the Act. Under the new construction contract, under the new Construction Act, then you do pick up also verbal contracts. And you can imagine that there's a difficulty with verbal contracts because one party would say, oh, we agreed something, and the other party will say, no, we didn't agree anything. And so the adjudicator is then left with how does he determine which party is telling the truth, effectively, on this verbal contract side. So obviously people in the construction industry don't like relying on verbal contracts because it all comes down to evidence. In one of the earlier seminars I gave you, I said about evidence under adjudication or any civil litigation is on the balance of probabilities. So if you were the adjudicator, you had this issue as is there a verbal contract or isn't there a verbal contract, you would have to go on the basis of balance of probabilities. The balance of probabilities would be probably there's not a verbal contract rather than there is a verbal contract until you're proven that there is a verbal contract. And so you can see the evidence is quite difficult then in terms of verbal contracts. But the point to remember, and it comes up quite often, is that you can now pick up adjudication provisions under a verbal contract. Now, what the Act says is that a party to a construction contract can refer a dispute to adjudication at any time as long as that provisions comply with the Act. And when we speak about a dispute, when you go right back to the beginning, people thought that you'd have an issue, say for example, a variation under a contract. One person says, oh, I think it's worth £5,000, one says nil. You go to the adjudicator and he decides what the answer is. Then he moved on, and really what the dispute now is, perhaps the whole final account. The whole final account for the job is a dispute. But that dispute will have loads and loads and loads and loads and loads of sub-issues within the dispute. But what you can't do is you can't refer more than one dispute to adjudication. So for example, if you had a dispute about an extension of time, which had nothing to do with, let's say, an interim valuation, then you couldn't refer both of those to adjudication at the same time. What you could do is if you could show that the extension of time related to something within the interim valuation, then you could say well, it's all under this umbrella of this interim valuation. Now, once you got over this first hurdle of saying it's all one dispute, there can be multitude of issues. Sometimes I had an adjudication recently, a couple of weeks ago, where there was about 35 lever arch files full of the sub-issues to the dispute, which was about valuation, an interim valuation for the works. So you can see it's a massive range, but it still has to be one dispute. You can't refer more than one dispute to adjudication. But people often think the one dispute means it's one issue. It doesn't mean it's one issue, it means it's one dispute. As I say there, the dispute can have many parts. Now also, what you can't do, and again, funnily enough, I've got one right this very moment, very rare situation where somebody has already had a decision on a dispute. They obviously didn't like the decision on that dispute, so they're now going to another adjudicator to say, well, can you decide this dispute on the hope that they'll get a better result? Well, obviously, what the Act says, you can only decide a dispute once. You can't go back to adjudication with the same dispute. So you're bound by that dispute. So in this particular case, I'm the adjudicator the second time round, and it's only just come up over the last couple of days. So the parties have gone through this process. They've had a dispute resolved. The adjudicator's come up with a decision. One of the parties didn't like the answer, so they've now come to me and said, can I decide that dispute? The other party has said, no, you can't decide that dispute because it's already been decided in the past. What's going to happen over the next few days will be both parties will explain to me why I can or why I can't decide this dispute. One will say, well, it's a different dispute, it's not the same dispute, and the other side will say, no, it's exactly the same dispute and it's already been decided. Me, as adjudicator, I have to decide, have I got jurisdiction to carry on? Because if it's the same dispute, I have to resign. I can't carry on with it if it's the same dispute. But if I decide, well, actually it's a different dispute, then I can carry on. I'll come up with a different answer, perhaps because it'll be a different dispute. It won't be the same dispute decided. But you can't decide the same dispute twice. Now, the provisions of the Act say that you have to be allowed to give a notice of adjudication at any time. Some of the contracts you might have dealt with so far, like the NEC, for example, the NEC says that before you go to adjudication, you have to first go through a sort of a process of trying to resolve the dispute with the other side without going to adjudication. And in the early versions of the NEC, that was the provisions of the contract. But then when it went to court, the court said, no, you can't do that because the Act says you can go to adjudication at any time. And therefore, as a result of that, the NEC produced two different provisions. One was for use outside of the UK and one for use in the UK. And the one inside the UK said you can go to adjudication any time, effectively. That's what the Act says. You don't have to go through any other process, you don't have to go through a mediation, you don't have to do anything else. You have to have a dispute. Once you've got a dispute, go to adjudication on it. And that's a really important point again, because often people are trying to slow down the process by saying there's other things that need to be done first. But the whole key thing is that you can go to adjudication once there is a dispute at any time. And the purpose after that of the Act says that you are to refer the dispute within 7 days. Now, by referring the dispute, what that means is that first of all, you issue a notice of adjudication to the other side to say, I am going to refer this dispute to adjudication. But after that, you then issue the statement of case, the referral, we called it the referral, but it's really the statement of case, and it has to be issued within 7 days from the date of the notice. And within that same 7 days, you have to have an adjudicator appointed, and the referral has to go to the adjudicator, and it has to go to the other side within 7 days. Now, if it doesn't go within 7 days, if it goes on day 8, then it's invalid, and therefore you'd have to start the whole process off again. Or you might not be able to start the whole process off again. And there have been cases where people have left the idea of going to adjudication until very late, long time. And for example, one case was where the limitation period was 6 years, was one case, and they didn't start the adjudication until almost the 6-year period was up. By the time they started adjudication provisions, obviously it was too late because the limitation period then kicked in. Another case was where there was a final certificate issued, and the parties, with the final certificate under JCT contracts, you have to start adjudication within 28 days of the date of the issue of the final certificate. Well, the parties, again, it's quite difficult to do it in 28 days because you've got to get all your case together, you've got to do everything of this nature. Anyway, the parties in that case issued the notice of adjudication, but the referral then was sent but too late. by the time they wanted to reissue the notice of adjudication, it was past the 28-day period. And they, very luckily, the court let them off the hook and said, oh, okay, you can, because you'd already issued one notice in time, we'll allow you to issue another notice. But they could just as easily not been allowed to do it, because the courts sometimes go one way and sometimes go the other way. You can't always predict which way they're going to go. But the key thing is, when you start off the adjudication, you have to have notice adjudication. Within 7 days, you have to refer the dispute. The notice purely says, effectively, we've got a dispute, and the referral says, what is the dispute? It gives all the details of the dispute. Now, once that dispute is referred to the adjudicator, within that 7-day period, he has 28 days to decide that dispute. Now, 28 days sounds quite a long time, but bear in mind, in that 28-day period, first of all, the other party will want to put a submission in, and then the party who's referring the dispute will want to put another submission in, and then the other side will put another submission in. You might have a meeting to go through the whole dispute, etc. And therefore, that 28 days gets thinned down to perhaps only a few days, and perhaps you have a meeting, which then pushes on. But the Act says that the adjudicator has to decide the dispute within 28 days, or the referring party can agree to extend that period by 14 days off their own back. So that if the adjudicator said to the referring party, look, I've had lots of submissions coming backwards and forwards, can you give me more time? Then the referring party can say, yes, you've got another 14 days. Or another alternative is both parties could agree to extend it past that 14-day period. More often than not, I'd say 90% of all adjudications are carried out within the 28 to 42-day period. So you can see it's a very, very short scale compared to arbitration, where probably the minimum you're looking at is about 4 to 5 months, and that's very quick. Court, it could be a year. So you can see it's a very, very fast process. Now, when the adjudicator considers this dispute, what he's looking at and what the Act imposes upon him is that he's got to, first of all, ascertain the facts and then apply the law. So you always, and that's quite a useful phrase to remember, ascertain the facts and apply the law. And if you're thinking along those lines when you're actually presenting a case to be decided, or if you ever get in a situation where you're in a dispute and it's going to go to adjudication, then you have to think to yourself, well, when it comes to this person called the adjudicator, he's going to ascertain the facts and apply the law. He's not going to actually investigate the facts, particularly in the time he's got, because he is going to be presented with the facts by you, and he'll go through all the documents, and he won't have time to start thinking of other facts. He'll just sort of relate to the facts you've given him. And often, even with the law, if you're dealing with adjudications all the time, there's literally hundreds now of court cases. In the last 20 years, this must be one of the most dense court case scenarios. So every year you might get 20 or more important court cases on adjudications. There's always a moving target. And adjudicators will often know these cases enough to know the issues. They might not know all the details, but the way adjudication works, unless you raise these cases with the adjudicator, even though it does say the adjudicators take the initiative in ascertaining the facts and applying the law, all they will actually do is they'll ascertain the facts based on what you tell them, and they will only apply the law on the basis of what you tell them. They won't actually go outside that parameter. What some adjudicators do is, if they know that you've missed a particular case that you should have referred to, they would say, could the parties address me on this particular case? Only because they know that is a key case that they really want to pick up on. But they don't want to pick up on it without the parties referring it to them in the first place. And the Act still continues to say that obviously the dispute is now, when the decision is reached by the adjudicator, that is binding on the parties. We called it temporarily binding on the parties, the reason being because the same dispute can go to be resolved either by arbitration or litigation. And the reason I say either by, you have to look at the contract, because the contract will have a provision in there for the final dispute resolution, either arbitration or litigation. You can't have both under a contract. You either have arbitration or litigation. And more often than not, now, under the construction contracts, they're litigation rather than arbitration, whereas 20 years ago, the final method would have been arbitration. But the adjudication still carries on irrespective of that. You could even have a court case going on, and you could go to adjudication while that court case is going on. It might be a bit pointless because you think, well, it's going to be resolved in court anyway, but there's nothing to stop you because you can go to adjudication at any time. Now, the Acts also say that there has to be a provision within the terms of the adjudication which allows the adjudicator to correct a clerical or typographical error within his decision. And that's an important point as well, because when the adjudications first started off, it was all a bit, nobody really knew how it was going to work. So when the first case went through to court, Maycop and Morrison, back in 1998, the courts were very supportive of adjudication, and they said that an adjudicator's decision will normally be enforced unless there's some major reason why it can't be enforced. And we'll come on to the reasons why it can't be enforced in a moment. But generally, they're saying that we will enforce adjudicators' decisions. But there was cases in the early days where, for example, an adjudicator may have just added up a row of figures incorrectly, come to an answer that was totally wrong. When the parties went back and said, well, look, you added up these row of figures wrong, you come to the total wrong answer, the adjudicator would say, well, I'm what they call functus officio, which means I've got no more functions under this now. I can't do anything about it. You know, I've finished my decision, that's the answer, it comes to that. I know it might be the wrong answer, I can't do anything about it. And when it went to court, the court said the same, well, that's the nature of adjudication. You know, if it comes to the wrong answer, it comes to the wrong answer. Hard luck type thing. But because of that, the new Act says that you can correct typographical or clerical or typographical errors within the decision, which is quite an important point, obviously. There's a restricted time scale for doing it, 5 days under the Act for correcting decisions, but even still there is that provision. But don't think this means that just because you get a decision you don't particularly like, it means you can then say to the adjudicator, could you give me a different answer? It's purely on the basis that he's made a typographical or clerical error in his decision. And the courts are quite, we'll come on in a moment to a jurisdiction, the courts are quite strong on the basis of as long as the adjudicator has answered the right question, that's the key thing. As long as he's answered the right question, it doesn't really matter what his answer is. His answer doesn't have to be right, it could be totally wrong, but you've got to comply with his decision as long as he's answered the right question. Well, obviously there's a lot of criticism in the construction industry where people think, so he can come up with a totally wrong answer, effectively, but because he's answered the right question, we have to comply with it. And that is the answer, yes. The courts say, yes, you have to comply with it, because these adjudicators, qualified people, they know what they're doing. Sometimes they make mistakes, and if they do, you have to live with it. But there are things that do allow you to overturn an adjudicator's decision. Another important point is that the adjudicator, unless he acts in bad faith, he is not liable for anything carried out in terms of whether he's the act or omission that he carries out is not liable for that. So obviously, you can imagine sometimes these adjudications, you're talking about millions of pounds being awarded through an adjudicator's decision. And if an adjudicator did, for example, by mistake come to the wrong answer, but he's answered the right question, it could be so important to a company, it might make a company go out of business, for example. You know, it may be that he awards £5 million and the company doesn't have £5 million, it has to fold the company up because it can't afford to pay the bill. And afterwards, it might turn out, well, actually, the adjudicator got it totally wrong, and it shouldn't have been £5 million at all. It should have been nil, let's say. But as long as he hasn't acted in bad faith, there's no liability on the adjudicator for that. So otherwise, adjudicators would obviously be very nervous about doing the job in the first place, because if the liability came back to them, they would never, ever be able to carry out the work. So that's quite an important point to bear in mind. Now, as we said right at the beginning, if those provisions that we were talking about in terms of what the Act says you have to have in the construction contract are not in the construction contract, then the scheme provisions come in place instead. And so the scheme is a fairly short document. Both the Act and the scheme actually is well worth downloading them. The parts of the Act you're talking about is only 10 pages long, and the scheme is 10 pages long, and it's fairly easy to read. What's made it slightly complicated is you've got two versions of the scheme, and you have to read the two schemes together. But if you go onto the internet, you'll easily be able to download one that's already been amalgamated together. But that's not how the Act, that's not how the government issue it. But lots of legal firms are actually amalgamating them. You can just download it from there, and it's quite a useful document to read through. Bearing in mind, all of this is, when you get into the construction industry, this is, in the UK, this is the only means of resolving disputes, effectively the only means of resolving disputes. You can go to court, you can go to arbitration, but in the UK, 90% of all disputes are resolved through adjudication. If you go internationally, you're starting to get it. Australia, New Zealand, Singapore, Ireland, places like that are starting to use adjudication. Lots of other places around the world are thinking of using adjudication. Other industries are thinking about using adjudication, and it will grow more and more over time. But they're all based upon these acts and based upon these schemes. They've got slight twists and turns, but basically they're based on this. So you really, as you get into the industry, you really would need to understand how these operate. So going back to the procedure, the first thing is there has to be a crystallised dispute before you can even go to adjudication. And by a crystallised dispute, what that means is that you can't just say to somebody on day one, oh, by the way, you owe me £2 million without any other reference, and then say, oh, if you don't pay me the £2 million, I'm going to go to adjudication tomorrow. Because the other party would say, well, what is the £2 million? What's it all about? I don't understand it. So you have to have some dispute crystallised. In other words, you have to put together, for example, an account or invoice, and say, this is how I arrived at my figure, this is why I arrived at my figure, etc. You have to allow the other side to come back and say yes or no. But if you think, well, they might not come back for 6 years before they say no, but the courts have said as long as you allow a reasonable time for them to come back and say yes or no, after that time there is a crystallised dispute. But none of this can kick in at all until you have a crystallised dispute. So you must have a crystallised dispute. A notice of adjudication must be served on the other side. The notice of adjudication doesn't have to be very long. Mostly notice of adjudications which we issue regularly, are 2 pages, and all it's saying is who the parties are, what the contract is, what the project is, and what the dispute is in simple terms, and what you're looking to be out of it. I paid some money or an extension of time or whatever it is you're looking for. So it's a very short document, but it's the most important document of all in the whole process, because from that it sets the jurisdiction of the adjudicator. So the jurisdiction of the adjudicator is set from that document. So, for example, the document might say, we've got a dispute, we put an invoice in for £1 million, the other side didn't pay it, therefore the dispute is we want to be paid £1 million. And that's they call that the redress, is we want to be paid £1 million. Now, that's the jurisdiction is set by that. So if you go to adjudication and the adjudicator decides after all this process, actually, I think it's £900,000, he can't decide the £900,000 because you said, I want £1 million. You didn't say I want £900,000, you said I want £1 million. So because of that, and again, these are lessons that have been learnt through the case law, which may or may not be right, but anyway, these are how the case law goes. You have to say £1 million or such other sum as the adjudicator may decide. So then his jurisdiction is widened to say you're not bound by that particular figure, but you can come up to some other figure you think, hopefully, it'll still be about £1 million, but you've got jurisdiction to decide it. And the same for an extension time. I'm looking for 20 weeks extension time or such other period as the adjudicator may decide. And the reason for those is because the jurisdiction of the adjudicator comes from the notice of adjudication. And jurisdiction, as you probably dealt with in loads of other parts of the course, means that's what the adjudicator can do. That's his job, is defined by that particular thing, to decide that particular dispute within those particular parameters. He can't go outside that because that's his job. And that's what will come up probably when this issue I was saying earlier about the same dispute being referred to me as has already been referred to somebody else. They'll send me the notice of adjudication for the first adjudication, they'll show me the second notice, and I will have to work out actually is there an overlap between the jurisdiction between the first one and the jurisdiction between the second one. So it's a very important document. As I say, it's a very short document. It just sets out really what is the dispute about and how much you're looking to get out of that particular dispute. And it has to be very precise, not only for that issue about, or such other sum, etc. It has to be precise about the parties, the names of the parties, and you'll be quite surprised at how many times people get the names of the parties wrong, the project, the contract. All these things have got to be absolutely precise, because this is where the whole process starts and this is where the jurisdiction comes from. Also, sometimes in a contract you'll have adjudication rules in the contract. You don't always have the rules, because sometimes if you had no adjudication provisions in the contract at all, then the scheme would come into play, and if the scheme came into play, that effectively are the rules that you operate under that contract. If you work under some other contracts, they actually say, well, these are the terms of the adjudication provisions, but also this set of documents, this, so for example, CMAR rules, as it was for the JCT would be, but now they've changed the scheme effectively, but they'd have particular rules that you have to follow. And these rules, all they're doing is saying, this is how the adjudication process will be applied under this contract. So you don't have any choice as adjudicator, you follow the rules of the actual contract that's applicable. And the adjudicator must follow those rules, because again, if he doesn't follow those rules, he's outside of his jurisdiction. If he's outside his jurisdiction, his decision won't be enforced. But going back to the procedure, so first of all, the notice of adjudication is issued. Within 7 days of that, a referring party has to serve the statement of case. The referral, in the construction adjudication, it's always called a referral, but effectively it's a statement of case with all the backup information. And like I say, sometimes you get a statement of case which is 20 pages long with no attachments. Sometimes you get one that's 200 pages long with 40 leave right files or attachments. So you can't say how big the statement of case is going to be, because sometimes it depends on the dispute, the extent of the dispute, the evidence is provided. But all of that, whatever it is, has to be provided within 7 days. Now, if it's not served within 7 days, it's invalid, and therefore it doesn't count. So you have to make sure it's issued in 7 days. And also within that same 7-day period, you have to get an adjudicator appointed. So how do you get an adjudicator appointed? First of all, it could be in the contract, there is a name of an adjudicator. Oh, so-and-so is the adjudicator. Or, alternatively, more often, there isn't a named adjudicator, but what it says is the adjudicator will be appointed by a nominating body, and they might list out the nominating body. So, for example, the Royal Institution of Chartered Surveyors is a nominating body for adjudicators. So you would then go to the RRCS and say to them, could you give me an adjudicator from your panel to decide this dispute? They go through their list and say, oh, so-and-so will be the adjudicator. or whoever it is who's listed in the contract you go to get the adjudicator appointed. But this has to be done within that same 7-day period, because the referral has to go to the adjudicator within 7 days. Otherwise, the adjudication is really invalid at that point, and you'd have to, in theory, start the whole process off again. Now, the notice of adjudication, if you remember, was the one that sets out in simple terms what the dispute's about, but the referral sets out in detailed terms what the dispute is about. So the referral is now really an expansion upon the notice of adjudication, setting out all of the contractual provisions you're relying on, all the evidence, all the case law you're relying on, any other documents and any other information you're relying on for your statement of case. And bear in mind, again, with any of these dispute resolution processes, the two fundamental points, particularly with civil litigation, are, first of all, the burden of proof is he who asserts must prove. So he who asserts must prove, i.e., if you're putting forward a case, you've got to prove the case. The other side hasn't got to disprove the case, you've got to prove the case. He who asserts must prove. And standard of proof is also the balance of probabilities, which I think we spoke about before, on the basis that you're not trying to prove it beyond reasonable doubt, you're just trying to prove it on the balance of probabilities. So whenever you present a document, a referral for adjudication, these are the two fundamental things you have to have in your mind. Have I given enough evidence to the adjudicator to satisfy him that I've proved the case on the balance of probabilities? So you really have to keep that in mind as well. Bear in mind, as we said, the adjudicator is to ascertain the facts and apply the law. So the facts have to be presented in a format that the adjudicator can understand and make it simple for him, because he's got a very short time to decide this dispute. So you've got to make everything very simple for the adjudicator, not because they're not intelligent people, but because they get flooded with information and that you need to make it quite simple. These are the points we want you to look at. And we've found, Matthew and myself, we find from our experience that when a party sometimes puts forward a referral, it's so difficult to understand, you can't even follow it. So the adjudicator's got no chance, and if the adjudicator can't follow it, he will tend to say, well, therefore you haven't proven your case, and therefore you've lost your case. So again, these are all very important points for the presentation of claims generally, and particularly for adjudication. Also, don't assume that the adjudicator will know all the case law. As I say, there's probably at least 300 to 400 cases now on adjudication. The adjudicator won't know, and some of them are slightly contradictory to each other. And some of them seem as though they don't quite relate to the same issue, or they relate to similar issues. But it's up to you to present the case law you want the adjudicator to look at. So again, the adjudicator won't particularly go outside the bounds of what you tell him. All the time, it's you tell him and he will decide the dispute. So after the adjudicator's got this statement of case or the referral, this is after the 7-day period. The 28-day period starts from then. So it doesn't start from the notice of adjudication, it starts from the referral. So when the referral is received, that's when the 28-day period starts. But in theory, and we've seen it occasionally happen, that after the referral, there's a response from the other side, after 7 days normally, and there's no other submissions at all. But more often than not, what happens is there's a referral, there's a response, there's a reply, there's a rejoinder, there's a summary rejoinder, there's a rebuttal, there's a summary rebuttal, and so on and so on and so on. And all the time is getting eaten into, and the parties then might agree to extend that 28-day period. So it doesn't always go in 28 days, but from our experience, I'd say most of them are 28 days to 42 days, so it's still a very fast process. What's quite strange with these further submissions, again, we see it all the time, is that each further submission says exactly what was said in the first submission. But they get longer, you think they get shorter and shorter, but they get longer and longer. as if to say to the adjudicator, you really got my point about this. And the adjudicator by then is getting so fed up, thinking, you've told me this about 100 times. I don't want to hear it anymore because I already understand the point you're making. But you can't say that, obviously, because that would come across as though it's a breach of natural justice. But anyway, so you can see there's lots of submissions that come into this process. And sometimes there's a meeting held. Now, people often think, oh, there's always a meeting held in adjudication. It's rare. It's very rare. I'd say 1 in 20 adjudications you have a meeting. Nearly all of it is documents only. It's very rare to have a meeting. In arbitration, you always have a hearing or a meeting. In adjudication, it's very rare to have meetings. So again, it's very important, therefore, that the information is put in the documents, because if it's not in the documents, you can't rely on anything else other than what's in the documents. So, as I say, 28 days is the base period, 42 days it can be extended by up to 42 days by the referring party alone, but after that, both parties can agree to extend it beyond that. The adjudicator can't, off his own back, say, oh, I think I want another 20 days to decide this. If the parties say no, you've got 42 days, then he has to reach his decision in that 42-day period. He can't decide, I will extend it. It has to be the parties who agree to extend it. When the decision comes out, there is no appeal process. If you go to court and you get a judgment in court and you don't like the judgment, then normally, if you're permitted to go to appeal, then you can go to appeal to a higher court and say, oh, can I have a look at this dispute again, or look at the judgment of this earlier lower court and see whether or not we can appeal it, overturn the decision. But you can never overturn a decision in adjudication. You can do two things in adjudication. One is you can go to court or arbitration to have the dispute decided again. That's not overturning the decision exactly, but it would become supplanting that decision. Or the other way is to say that the decision can't be enforced because of various factors, and we'll speak about those in a moment, but there is no way of appealing against the decision. You're bound by that decision. And obviously another big issue in terms of dispute resolution is the issue of costs. And whichever way you go, whether it's arbitration, litigation or adjudication, this is one of the first questions people ask. Like, I've got this dispute of £50,000, how do I resolve it and how much is it going to cost me to resolve it? Well, traditionally, adjudication has been the cheapest option for resolving disputes because you've got two types of cost in adjudication. One is the adjudicator will charge a fee for doing his service. His fee would be perhaps somewhere between £5,000 and £25,000. So again, depends on the size of the dispute. If the dispute's only £25,000 and the adjudicator's going to charge a fee of £25,000, let's say, then it makes you think, well, is there any point in going to adjudication? Apart from, with the adjudicator's fee, he normally charges it on the basis of costs follow the event. So what that means is that if a party wins the adjudication, then the losing party would normally be responsible for his fees. There's no set rule on this. This is just the general rule that adjudicators follow. And so as soon as a party wins the adjudication, the other sub-party is liable for his fees. But he still says both parties are jointly and severally liable for my fees, which means that if the party he says has got to pay his fees don't pay his fees, the other party would have to pay his fees anyway. So that's one factor. Obviously, if the dispute's large and his fee, say the dispute's £2 million and his fee's £20,000, doesn't really matter that much because the proportion is pretty small. But if the dispute is small, then it makes a big factor. The other big factor is that the party's own costs for running the adjudication. So if you appointed a solicitor to present your case for you, run the adjudication, whatever that cost is, you can't recover that cost in the adjudication. Normally, you can't recover that cost under the adjudication, whether you win or lose or they're equal. So whether you win, lose or draw, you can't recover your own costs in the adjudication process. So you can see again there, that's a big factor, because it could cost you £20,000 to run adjudication, could cost you £40,000 to run adjudication. But if you win, lose or draw, you still end up paying your own costs. There's a bit of a debate at the moment in the adjudication world about can you actually recover your costs, because some people say that actually through the Late Payment and Commercial Debts Act and the latest regulations under that, you should be able to recover the cost, debt recovery cost, and therefore that should be the cost of adjudication. There was a case which people rely on, which is called Lulu versus Maladi, which people rely on to say that you can do it, but it didn't actually say that. All it said was the adjudicator in that particular case had decided that the parties could recover their costs, a party could recover their costs, but because of the issue that we just spoke about, that a court will never overturn a decision whether it's right or wrong, the court said, well, it's enforceable. And therefore, because of that, people think you can recover the costs. But I think it was purely that you can't overturn that decision. So, and the court, or I think the wording was something like, even if the adjudicator is wrong, we can't overturn it. So I didn't actually say the adjudicator is wrong, but they were saying, even if he is wrong, we can't overturn it. So I wouldn't rely on that. But there is still a big debate about whether you can recover the costs or not. Balance of people say you can't recover your costs in adjudication. So it's a big factor again in terms of the cost of dispute resolution. Now, when you get this decision through from the adjudicator, and it might say to one party or the other, you've got to pay considerable sum of money. It might be £1 million, it might be £50,000, it might be £2 million, whatever it is. The adjudicator will say party A has got to pay party B £1 million. And all that would be is a document like this with all the build up to how he arrives at his decision. At the last page it will say party A has to pay party B £1 million. But obviously if you were party B and you've got to pay out £1 million, you think, oh, I don't really want to pay out £1 million. All I've got is a piece of paper which just says pay £1 million. I'm not going to pay it. So what has to happen there, and it doesn't happen very often because most people do comply with the decisions most of the time, but if they don't comply with the decision, you have to go to the Technology and Construction Court, which we just call the TCC, for an enforcement of an adjudicator's decision. And there's a very fast-track process that the TCC operates to enforce adjudicators' decisions. And generally, adjudicators' decisions will be enforced other than for things such as the procedure hasn't been followed as per the contract. The adjudicator has decided outside of his jurisdiction, so he's decided something that wasn't in the notice of adjudication, he's decided something outside of that. He's been biased, he's breached the rules of natural justice. So for example, it could be that somebody puts in a document, even though he hasn't asked for the document, they off their own back and say, oh look, there's this further document we want you to consider. And the adjudicator still has time to consider it, but he writes back and says, look, I told you I don't want any more information, therefore I'm not going to consider it. The possibility is the court would say, well, you breached the rules of natural justice because you haven't considered all of the evidence that was given to you. So when we say about the fact that a decision being enforced, it will always, nearly always be enforced other than for these types of things: procedural, bias, rules of natural justice, outside jurisdiction. But apart from that, as long as he's answered the right question in the right way, it doesn't matter what answer he comes to. He can be wrong with facts, he can be wrong on points of law, he can be wrong on adding up the figures, he can be wrong on everything else, but as long as he's right in terms of following the right procedure, not being biased, doing what the notice of adjudication asks him to do, it will be enforced. So you can see, looking at it from an outsider's point of view, you think that can't be right. So you can come up with a stupid answer, but we still have to comply with it, and the courts will enforce it. And the answer to that is yes, they will, because they say that sometimes, because there's a bit rough and ready justice, sometimes you'll get a good decision. Sometimes you get a bad decision. Hopefully most time you get a bad decision. But on average, we've got to comply with these rules, and these rules are an adjudicator's decision will always be enforced. And so if the adjudicator gets the wrong, what we call the wrong answer, i.e. everyone can see afterwards that can't possibly be right, but he's answered the right question, the adjudicator's decision will be enforced. And it's a very, very important point to remember under adjudication, which doesn't come into court, obviously, because if you had a court situation, judgment there, the next level court could say, well, actually, it was wrong, and the decision is then, or judgment is overturned in that case. So the adjudicator's jurisdiction, which we spoke about earlier on, is where things may come up in terms of why you might not get the decision enforced. I've listed out some of the most common ones. First of all, that there is no construction contract. So if you haven't got a construction contract, then you haven't got the right to go to adjudication in the first place. And as I said, if you have a supply-only contract, then you haven't got the right to go to adjudication. It's got to be a construction operation covered by a contract as defined by the Act, and then you have got the right to go to adjudication. You might have no right to use adjudication. For example, a residential occupier has an exemption under the Act, in which case you can't go to adjudication with a residential occupier. So that's another reason why the courts would say, I can't enforce a decision because it doesn't comply with the Act. The wrong appointments procedure. So we spoke about the fact that you might have a nominating body in the contract, the RICS, for example, but somebody goes to the Royal Institution of British Architects, for example, and says, oh, could you give me an adjudicator to decide the dispute? They do it. The adjudicator goes all the way through the process, comes up with a decision. The other party was saying, well, it's not valid because he wasn't appointed correctly in the first place through the process that's in the contract. So again, there's another reason why the courts would likely throw it out in terms of the decision. The wrong adjudication rules, there might be particular rules in the contract that are set out and the adjudicator doesn't follow those rules. You might think, well, it wouldn't really make any difference, it actually follows these rules. The decision will be exactly the same whether you follow those rules or if you follow those rules, but if he doesn't follow the rules in the contract, then again, it won't be enforced. No dispute or more than one dispute. This is another, a lot of these topics kind of go round a little bit in circles because they come up as an issue and then we think they're resolved and then they come up as an issue again. So in this case, you've got no dispute, so i.e. you've got no crystallised dispute. You've never been given the opportunity to actually say what you think about the dispute. You've never gone back with any comment about the dispute and suddenly you're into an adjudication, so there's no dispute in the first place. Or it might be you've got more than one dispute, so you've been asked to decide more than one issue or more than one dispute in adjudication, which you can't do. And at the moment, there's an issue that if it's a statutory adjudication, the same adjudicator can't decide two different disputes at the same time. So that's all to do with the same thing about one dispute. So you can see there's lots of little technical issues with adjudication that have to be thought about in the actual process. Dispute already decided upon, so somebody's already decided the dispute in the past. You can't re-decide that same dispute because it's already been decided. Breach of natural justice typically could be that you don't accept or you don't take into account all of the documents that are given to you by both parties, or you might have a meeting where you refuse to let one party say what they want to say or something of that nature. So by breach of natural justice basically is that you have to allow both parties a fair opportunity to present their case. Now, that's across the board, not just for adjudication and all sorts of dispute resolution processes. Natural justice means you have to allow both parties a fair opportunity to present their case. But obviously, if you had a court case that went on for 2 years, your parties would have a better opportunity to present their case than they would if you got a process that takes 28 days. So whenever courts are deciding have you breached natural justice, they're deciding not only what is this thing you've breached, but is the timescale that you've actually set fair for that particular process. There's a key thing, breaching it rarely happens because adjudicators are doing adjudications all the time, know all of these problem areas, and they normally always cover all these areas and think that will allow you to put your case as much as they possibly can. So they don't want their decision not to be enforced. They want their decisions to be enforced. One reason for that, selfishly as adjudicators, is they might not get paid their fees if their decision is enforced. So obviously they want to make sure their decisions are enforced. And another one is bias. So bias could be that one of the parties happens to be a company owned by your brother. And you might possibly, unless you don't really like your brother very much, you might be biased towards your brother. Or it might be a company who you've done business with in the past. And again, that's bias because obviously perceived bias, or rather than actual bias sometimes, that people would look at it from the outside and think, well, you must be in favour of that company because in the past they've employed you to do work and therefore they've paid you money for doing the work, therefore you must be biased. So these are all other factors that why it may not be enforced. But principally, adjudicated decisions will be enforced other than for these issues. I think that's really a run through of how adjudication operates in the UK, the process, the pitfalls, the problems, but obviously there may be people who actually dealt with adjudications here or come across adjudications or might have questions about adjudication process. So if there are any questions.
Well, first, thank you, Peter. As usual, there was a lot of information, very useful information. I have a few questions. I'll try to make my 3 questions at once, and I'll pass the microphone for someone who's wants to ask something. About the award. It's a revocable award. Is it correct for me to say that the adjudication award is revocable, and what does it mean?
Right, well, first of all, an award under adjudication is called a decision.
A decision.
Yeah.
Thank you.
That's because award is an arbitration award, but adjudication's decision, they call it. And when you say revocable, it's not appealable. You can't appeal against it. All you can do is you could go to court or to arbitration, whichever applies under your contract, to have that same dispute decided by somebody else. But until that is decided by somebody else, the decision of the adjudicator is bound, you're bound by it. So that's why we call it temporarily binding, but it could be permanently binding because if you don't actually go to arbitration or court, then it's permanently binding as well, Can
enforce. I heard recently that you can challenge the jurisdiction of the adjudicator on apparent bias, not only factual bias. How does it work?
Well, what happens in the first place is if you're appointed as the adjudicator from a nominating body, each nominating body, the RICS is the biggest nominating body in the Royal Institution Chartered Surveyors. The RICS is the biggest nominating body in mainstream construction adjudication. And they'll have probably about 150 or so adjudicators on there. So when an adjudication comes through to them and they're asked to appoint an adjudicator, they then go to the adjudicator from their list at random, in theory, apart from the fact if people ask for a particular skill, they might go through the list, oh, he's got that particular skill. They go to the adjudicator and say, look, the parties in this particular dispute is party A, party B, perhaps even they're represented by so-and-so and so-and-so. Have you got any conflict of interest with those parties? So even before the adjudicator is appointed, the adjudicator should say, normally it's within the last 5 years, have I had any association with these parties or these representatives which might make somebody think afterwards there's some sort of possibility of bias, so some perception of bias. And if so, the adjudicator should say, I can't take that adjudication on, because the possibility is if I come to a decision, it might go to court, even though there is no bias, there's no actual bias, I've not done anything wrong, but somebody would say there's a perception of bias because it would look to an outside viewer that perhaps there is a bias because you are, like I say, it's your brother who runs the company or something like this. So therefore, obviously, it's not actual bias because you haven't done anything wrong, but it's perception of bias. And the courts are likely to throw it out on the basis that it's a perception of bias and therefore it won't be enforced. But actual bias obviously is where somebody can show that you've actually done something in favour of one party and rather than the other, which is harder, because how do you actually show it? Just because you come to a decision that favours one party rather than the other, it doesn't mean it's bias, it just means that that's the decision. It could be the decision anyway, sort of thing. But the perception of bias is always the problem area.
Well, my third and last question, maybe I still have one. Very quick one.
Yeah.
Can we challenge the jurisdiction of the adjudicator at any time?
Yeah.
Including after the decision?
Yeah, I mean, well, what the courts say is that there's two options really. The way most people operate is, first of all, as soon as the adjudicator is appointed, if you think there's some query about his jurisdiction, then you go back and say to the adjudicator, I don't think you've got jurisdiction because of this, this and this. You could possibly say, I'm so sure you've not got adjudication, I won't take part in this process at all, and you can just reach whatever decision you like because I'm not going to be interested in it. In which case, the adjudicator might come up with his decision, you might say, well, I didn't accept you had jurisdiction in the first place. The other side would still try to enforce it. When you go to court, then you would say, the reason I didn't take part is because I don't accept he had jurisdiction in the first place. And the court would take it into account if that was the case. More often than not, people reserve their position, say, we don't think you've got jurisdiction, we're still going to take part in the process, but we reserve our position, you don't have jurisdiction. So then when the decision comes out, obviously, if it's a bad decision, as they see it, they say, well, we've always said you didn't have jurisdiction anyway. So then when it goes to court again, they would still say, well, you never had jurisdiction in the first place, and the court would have to decide whether or not he had jurisdiction. So the answer to your question is pretty much yes, you can really raise that jurisdiction query any time.
Okay, now it's my last question. Yeah. Just a quick note, we have the scheme, the two versions of the scheme available on Drive. So now folder on Google Drive, so if you need, it's there, but we can also access it online.
Is that the amalgamated versions?
Yes.
Yeah.
The one you give.
Oh, right, okay, yeah. Because otherwise it's quite difficult to read if you have number one, number two separate. You've really got to bring them together.
Yeah, I'll make sure.
Yeah.
Well, my last question is that can you adjudicate an international decision, an international award of a dispute that was going on outside the UK and somewhere else involving?
Well, if it's based on English law, then yes, because there'll be a statutory adjudication. Or you can. I've carried out a couple in Dubai where the parties have agreed to put construction. In their contract, they put adjudication provisions because they were both international companies. They didn't really want to have to rely on the local courts because they know they can be a bit unpredictable, and therefore they decided to put adjudication provisions in the contract to try to resolve the dispute quickly and easily. So you can do it, but if it's based on English law anyway, then you have the statute. If it says the law of the contract is England or UK, but more often now England. Only because there's different law between Scotland and England, then you have the statutory right to go to adjudication anyway. And that does happen from time to time. Most of the disputes obviously are domestic, national disputes, but it could happen in international cases.
Thank you very much.
Thank you. When you mentioned that decision can be enforced in the TCC, which is Technology Construction Court.
Yeah.
Does it mean that it's being relooked into by people who's got experience in the particular area, or you just submit and they just validate it?
No. The only the judges are, in theory, construction specialist judges. but they're not looking at the decision particularly. All they're looking at is, has the right process been followed? You know, was there a right to go to adjudication in the first place? Were the right rules followed? Was there a breach of natural justice? All those types of procedure. You know, was the timescale met? Was the notice issued at the right time? Was a referral issued at the right time? Was a decision issued at the right time? As long as all the procedural, natural justice, bias issues, they tick, 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 yep, they're all okay. The decision, they don't look at. It's just like, well, that's a decision. No, you've proven that you've satisfied all these, therefore the decision's enforceable. So unfortunately, it's not like an appeal against that decision. It's purely have the right processes been followed.
Then the second one is, shall I say the maximum cycle for adjudication decision is 56 instead of 42?
No, there's no maximum. There's no maximum. If the parties, I mean, I've heard of adjudications going on for up to a year. Because if both parties agree that we want the dispute resolved through this process, they have to agree beyond 42 days. They both have to agree, but they could agree to go on for months and months and months if they want to.
So they can be extended by 14, 14, 14,
Yeah,
14
it could
days
be. It could be. It doesn't happen very often. Like I say, most of them are sold within 42 days. There's nothing under the Act which stops it going on for months.
And lastly, the Construction Act can it be regarded as the Payment Act as well?
Sorry?
The Construction Act,
yeah.
Can we regard it as the Payment Act as well?
Well, the Construction Act deals with the two main issues, which are adjudication and payment provisions. Yeah, so they're the two main issues, construction, that deal with it. So when you say, can we call it the Payment Act, it deals with all this business about default payment notices, payless notices, all those types of things all come under the Act as well.
Thank you.
Thank you.
Thank you, Peter. Quick one. You said something about so the adjudication process can be referred to at any stage in the construction process. However, if your contract states or stipulates specific processes to go through before adjudication, can you still jump those processes and go straight to adjudication?
Yeah. Because as the NEC, for example, originally had a process where you had to go through almost like a mediation process first before you could resolve it through adjudication. But when the court said, the Act says that you can go to adjudication at any time and you can't be fettered by some other process which slows it down. The Act says you can go at any time, therefore you can't have any other provision in the contract which stops you going to adjudication at any time. So, the answer to that is often you do see where people put in there, if there's a dispute, there's this informal type process first to try to resolve the dispute. And it makes sense to try to resolve it informally first. But if that informal process you decide is going on for too long, or you decide you don't want to follow that informal process at all, you just go to adjudication at any time. That's the whole point of adjudication.
Secondly, how does that affect litigation? So when you get into your litigation processes, and there's a question, what steps did you take in resolving this particular dispute?
Well, under construction disputes in litigation, you have this pre-action I don't know whether you've come across pre-action protocol for construction disputes. So what the courts like you to do is to go through this pre-action protocol first, which is to say you've tried to resolve a dispute before it goes to court. Now, if you've been through adjudication, the courts will normally accept that as being equivalent to the pre-action protocol, so you don't then normally have to go back through the pre-action protocol, because you can say, well, we've already been through adjudication, which acts almost as though it is the pre-action protocol anyway. But apart from that, you can go to court and you could go to adjudication at the same time. There's nothing to stop you doing both at the same time.
Maybe your pockets.
Yeah, apart from how much it costs you, I'm
afraid we ran out of time.
Yeah.
We will have Peter Thank you so much, you, Matthew, Blue Sky ADR, for the seminars you gave. I think we are all very happy and pleased that we learned a lot with your seminars, and they are forever on YouTube. So next week we'll have the last one, and we have our YouTube playlist, Westminster Construction Society. We have the president of the Westminster Construction Society, very fancy in here. So watch, like the video, share, and please, if you have any questions, comments, and etc., let us know. We will do our best to answer all of them. And a warm thank you to Blue Sky ADR and Peter Burns.